The legal proceedings surrounding the death of late singer Ireoluwa Aloba, popularly known as Mohbad, continued in court today as the matter came up for hearing following last week's adjournment. Speaking with journalists after the proceedings, a representative of the applicants' legal team disclosed that they had been served with an application for Joinder. However, the lawyer argued that the application was merely an attempt to delay the speedy hearing and determination of the case. According to the lawyer, the applicant seeking to be joined failed to disclose any legal interest in the matter, insisting that any party seeking Joinder must clearly establish their interest before the court.
If you are coming in as an applicant, you must demonstrate before the court that one, you have interests. In this suit, you never told the court that you are a police officer. You didn't tell the court that you are one of the people that sponsoring this proceeding. You just say, okay, you want the court to join you in the proceeding. So it is a kind of abusive process. And luckily, the court, even without hearing and looking at our own process, so much on his own, dismissed the application. Is a height of abuse of court process.
The lawyer further stated that the court agreed with their position and dismissed the application, describing it as an abuse of court process. On the substantive matter, the legal representative explained that the applicant approached the court as human rights advocate, seeking leave to commence proceedings. The court granted the application for leave, paving the way for the substantive action. The lawyer also stated that the police were duly served with the court process, but did not appear in court, adding that they believe the police absence indicates they did not challenge the affidavit before the court.
To apply for under mandamus, and interestingly, the leave was granted, which paved way for the mandamus itself. The police were duly served. They refused to turn up. They didn't file any process. So what it means is that they've admitted all the facts stated in our affidavit. So that is what happened today.
The matter has now been adjourned until September 29, 2026 for judgment and further proceedings.
The matter has been heard and judgment reserved till the 29th of September 2026. So that is the position of the case now. We have argued our matter, regardless of whether the police turn up or not. We've served them. We have done what is required of us to do under the law. They refused to show up, and we had no option than to proceed with the hearing of the case. And luckily for us, the matter was heard and adjourned for judgment.